kind of roar that we had in the days of Okongo Mogeni when I was a young reporter, covering them. LSK would speak and political actors would have to reconsider what they were doing. Now, they could be ignored. Frankly, what happened?
I think there's been also critical changes in the legal infrastructure. Remember, before 2010, there was the clamor and agitation for constitutional reforms, and the Law Society of Kenya played a critical role in ensuring that. In fact, if you remember the Guy Commission, the first draft constitution was actually developed by the Law Society of Kenya. But you see, following the promulgation of the constitution, much of the roles that now the Law Society of Kenya has reserved is making sure that the constitution is implemented in the manner in which it was intended, and that it achieves the objectives for which it was promulgated. So I think in terms of where the Law Society of Kenya is, Law Society of Kenya plays a critical role. It has functions that are internal to it and functions that are external to it. Functions that are internal to it are these practice issues, what lawyers care for, and those are what we may call in-house issues. But why this election also carries a lot of weight and significance across the nation is because of the functions that are external to the society. Under Section 4 of the Law Society of Kenya Act, the Law Society, still through the Council and still the Presidency of the Law Society of Kenya, is supposed to assist government in implementing the Constitution, ensuring compliance with the law and observance and adherence to the rule of law. These are critical functions. That means Law Society has a say in almost everything that is legal. In fact, members of constitutional commissions, any institution or any organ that requires representation of lawyers, Law Society of Kenya has a significant say in who sits there. And even if those persons are appointed independently, there's some level of superintendence over those persons that sit there. That is the critical role in terms of supporting the implementation of the Constitution. That is why I think this election is of significance. And I hope that the incoming council, we already have some information that how the election is going on. We can only pray that the incoming council does not falsify that vision. This Law Society of Kenya is not supposed to be a political institution. It's supposed to remain faithful to the objectives for which it is intended to achieve, which is support the rule of law.
But have you answered Andy's problem?
No, he did talk about some of the changes
because you
that
say
have taken place.
They don't seem to be biting.
Well, I think the question
that is, I think, the concern.
No. Let's say, to be fair to the outgoing council, people have different styles. If you distinguish Eric Mutua's style and the outgoing president, Isaac Okero was also equally firm and intense, but he was laid back in the sense that he didn't like issuing tough statements and also, confrontational approach. Eric Mutua was more visible in terms of number of press conferences.
But not necessarily more credible, if you like, in terms of, LSK used to take a position and the country would pause and rethink.
I've explained that part of the changes means also that since we've also transitioned and we have a new constitution, that has significant effect. But also the heightened political activity. This is the Law Society of Kenya. We still a body that operates within the Kenyan political space. So the temptation to infiltrate the institution by political actors to have a compliant society is always almost irresistible. But that is not to excuse the leadership of the society. They are supposed to remain true because LSK is a statutory body with statutory functions. They don't need to respond to external manipulation or interference.
Steve, I want to catch you on that because that is critical, because we've just come from such a heated election period where a lot depended on interpretation of the law. Yes. And Dunstan, for every lawyer in this city, there was a different interpretation of the Constitution. You remember, it became pretty much a joke on social media in terms of the Constitution clearly states. And then there go the divergent views of what it could be or not be stating. Have lawyers failed this country when it comes especially to giving interpretation to critical issues in the context of a high-stakes election? Did they fail us last year?
No lawyer failed the simple test of interpreting the law. There are more than 10 to 11 schools of law on how to interpret the law. The naturalists will have their own way, the positivists will have their own way, the Marxists will have their own way. All these are theories that are taught and philosophy is taught to every lawyer. It simply tells you why the judges at the Supreme Court, who are 7, will have different opinions over one matter. That is within the law. Lawyers will interpret the law based on who has instructed them. If I get instructions from a professor here, I will pursue the law with an interpretation that favors his case. So the citizen should not be expecting us to interpret the law from their point of view, because they are political in nature. So the lawyers did their job.
And lawyers are not?
And lawyers are lawyers based on who has instructed them. That is why today you see me representing a Jubilee client. Then I will be arguing to the law to the point that he's right. In the afternoon, I'll be defending a NASA client. I will be the same lawyer, but with a different legal perspective to law. So that is the only difference between the lawyers and the others. The only person allowed and paid by the state to interpret the law properly is a judge, is a judicial officer. And that is why two opposing camps of lawyers will present divergent views, but the judge will say the position of the law as settled is this one.
Prof, what kind of influence does LSK have politically?
They have a huge influence. The big influence that the LSK has is that if, for example, a law is passed in Parliament, which looks unfair to one faction and probably fair to another one, whichever side the LSK stands, stands to gain public support. The people think these are the real lawyers who know what to do. So if they say that this law passed by Parliament is not right, then it means it's not right. So it can eat into the political capital of the people who are occupying the political space. So that is the significant part of it. But in terms of interpretation of the law, in this postmodern society that we live, post-truth society that we live, it is difficult even to go by what Dunstan Omari is saying, that the judge is the one who is supposed to interpret the law properly. He used the word properly. In a post-truth society, post-modern society, how can you even settle for proper interpretation of the law? There are as many interpretations of the law as there are people reading the law. You have seen judges differing, even the public has been differing. There have been recent developments in this country where people have an opinion on what should have been done. Even with the election of 2013, 2017, people have different interpretations. But then we must probably think of a threshold where you don't get all the interpretation, but we can agree that it is a post-truth, post-modern society where there is no truth with capital T, but there are some truth with small t.
The relative truth.
The relative truth. So then we say, in this context, can we agree that this makes sense to us rather than it is the right way to do the interpretation? Right. So LSK, as an institution, I think we shouldn't also be too harsh on them. They have been operating in an environment, as far as I can remember from 2013, LSK leadership has pronounced itself on a couple of things, especially with regard to unconstitutional laws. I remember one was the security laws, and they said this is not correct. They have said certain things that go contrary to the political establishment. And that's what we require, because they are supposed to promote the rule of law as a basis of creating an acceptable society. And they have done it very well. They may not make noise taking sides in this kind of thing. And again, it is also the only organization where elections are held. And when they are held, you don't hear about rigging. I was ready even to represent some of them. I was expecting that what we should be hearing from the LSK headquarters, that somebody has rigged elections or stolen a debe full of votes. We don't hear about that. So if I were to represent them, I have nothing to do it. But for now, I think they have certain positives and they should be strengthened. I don't think that I can condemn them and say they have failed the nation. The people who have failed the nation is ourselves. Okay. Because we do things in a way that it doesn't make sense. Yeah.
Thank you very much for giving us credit, because the profession actually have done tremendous. The way the elections were conducted, peaceful, very professional. The councils, our colleagues.
Shouldn't you be congratulating the electoral
the
commission?
secretariat. No, we are all of them. The EIBC and the secretariat led by Mercy Wambua, they've done a tremendous job.
All right. Well, move on to other matters now. Of course, the Embu High Court, as you know, nullified the election of Governor Martin Wambora, saying the poll was marred with irregularities. Wambora has, through his lawyer, said he's going to appeal this decision. But in the context of the August 8th election, is this nullification significant, and what does it tell us? Steve?
I think it's significant in the sense that judges are interpreting the law and applying the law to the facts presented before it. But I think appealing is also a welcome consequence of the hierarchical order within our judicial structures. You have the High Court, you have the Court of Appeal, you have the Supreme Court. What I think we should capture and not lose, once a court has made a determination, let us not bastardize the judicial determination. Just go and appeal, present an alternative argument. The Court of Appeal may accept that argument or may not accept it. If you lose at the Court of Appeal, you still go back to the Supreme Court. There's that option. But I think if you look at the context in which election petitions are being managed, very few are succeeding. That tells you, in a way, politically, that IBC, its ability to manage the election, is now they're not getting vindicated. I mean, I think there were about 300 petitions. 388 petitions, and you see most of them have been determined. And I think so far there are about four. Just a handful that have been dismissed. That tells you that generally in terms of election management and the challenges of managing an election in an indisciplined country, because Kenyans, in terms of electoral democracy, people who observe our democratic maturation process will agree that the manner in which we manage our elections, although we like to blame IBC a lot, but we also have a problem, a cultural problem, a societal problem, a political culture problem that makes us excuse bad manners and bad behaviors from candidates, supporters, and all that, and then just pile pressure at the tail end on IBC and the judiciary. The fact that the judiciary is determining these cases independently without external pressure or influence tells you that on a good day, I think IBC has done a good job. Those who are not aggrieved,
it did a good job on August 8th.
It did a good job on August 8th, and that is now a matter of fact. You see, because out of these petitions that have been filed, few are succeeding. I'm not speaking for IBC, but that's a question of observation. The ones that, what I saw, because I was involved in a matter recently that now led up to this LSK election, where people, when they lose in court, immediately they bastardize that judgment. I think that's an attack, an indecent and unacceptable attack on the independence of the judiciary. It is not only government institutions that can threaten the independence of the judiciary. We need to sense as each other that even the ordinary mwananchi, the moment you make comments that devalue or delegitimize the authority of a judicial officer or of the court, you're actually threatening the independence of that judiciary.
But come on, Steve, this is we live in a society of free speech. One can take exception to
free speech, but with decency, with responsibility. That is what free speech is required. I am allowed to speak what I want, what can enter my imagination, but also conditioned in a manner that is acceptable in a civilized society. We live in a country where, Dunstan already said, in terms of interpretation of the law, the voice of the judicial officer is final unless reversed by another judicial officer of a higher rank. So it's not open to me as a lawyer who has argued a case before a judge to come out and drop it. If I knew that judge was not able to make it, why did I go there in the first place? I think the better place, and I think now this incoming council, LSK council, I'll come back to that issue. Let us have a conversation within the law set on what is decent and acceptable behavior, because that will have a ripple effect on the entire society.
Okay, I want to return back to the nullification. And Prof, we have seen Martin Wambora survive nearly a nuclear bomb. You know, he survives everything. Do you think he can make it again? Can he survive this?
This guy is a very interesting guy. You know, he's the sick man of devolved units.
He's the sick man?
Yeah, because he became, you know, he was the first casualty, and he was impeached. And that impeachment, if you don't know, Anne, it changed the way governors behave. In fact, they conspired and made sure that no more impeachment can succeed. So that is the significance of Wambora's impeachment. Now, if you take the impeachment as one thing, then the fact that now his election has also been nullified because somebody went to court, it shows that Martin Wambora should go home. Because this voice, if you combine the two, that there are a lot of people who think he can't be a decent leader by the fact that he was impeached, but he also can't win an election fairly.
But he, in equal measure, it could be the beacon of hope. Keep fighting, Martin Wambora. There always seems to be one more person who believes in you.
Let me tell you why I don't like Martin Wambora.
So you don't like him. Okay.
There are two versions of Martin Wambora. There is one thing. There's one. I don't like Martin Wambora because when he was impeached, he changed the political behavior of governors, and it has hurt us so much because they were even able to put together some funding to support each other anytime there is impeachment. And this is if Senate is listening to us on this program, Senate should know that they must dismantle the cartels involving governors that resulted from what Martin Wambora's impeachment did. So that's why I don't like him. But where I like him is the fact that Martin Wambora is also a really fighter. Even when you think that he's losing, he hangs in there. So I don't know what the next thing will be. But he must know that even when there's a time to call it quits in a fight, he was impeached. He came back through the conspiracy of governors. He has now been dismissed because of the court ruling. There is a message which is being sent to him by the people of Embu that probably you excite too much acrimony. If we continue like this, we shall finish another 5 years without making any progress. So he should accept the ruling of the court so that the leadership of the Embu gubernatorial post is determined in a more decent way and probably without
until
him.
A judge of a higher rank,
yes,
as he said, and does this. Okay, I'll talk about Lenny Kivuti. This man has, I mean, he has fought, he has suffered a great deal. Depending on how you see it, he's either the victim or something else. Remember from the days, you know, when he was getting ready for this seat, not just the first time round, but in this particular round, battling it against Cecily Mbarire, deciding to leave and go to Maendeleo, Chap leaving Jubilee. And he's a bit of the maybe comeback kid that it could be his shot. Do you think so?
Kivuti is a very seasoned politician. The senator, the surveyor, the engineer is quite a hard fighter. Wambora is a seasoned provincial administrator. He rose through the ranks to the airports. He understands the political terrain and the administrative terrain. And that is why he finds Kivuti might not succeed to lock him out. Under the Elections Act that we are using now, once they will file a memorandum of appeal at the court of appeal, Wambora, the orders of the High Court are stayed automatically. So Wambora will still be in office as the governor, as it has happened in Wajir, as it has happened in Homa Bay. They have 6 months to conclude the petition. So in my own view, I think that Kivuti has a bigger challenge to deal with a battle-seasoned politician in the Court of Appeal. And in my own view, I think that the Court of Appeal is likely to uphold the decision. It might not uphold the decision of the High Court. When I look at the trajectory, 388 petitions, only one member of parliament election has been nullified. Only 3 governors have been nullified. No senator has been nullified, and around 2 or 3 MCAs. What is the message? The message is very clear that the courts are looking at the decisions in the Supreme Court of Raila 1 of 2013 and not looking at Raila 2 of 2017. In those decisions, in Raila 1 of 2013, it is that the irregularities must affect the outcome. In Raila 1 of 8th of August, it was that the irregularities, so long as they have happened, that is enough to nullify an election. In the next Maraga 2 of 26th of October, the courts went back to Raila 1 of 2013 that the irregularities must affect the outcome. So when I look at the people who filed their petitions, very many filed their petitions based on Raila 1 of 2017. And therefore, in my own view, I think almost all the petitions that will land at the Court of Appeal, they will be, the courts will nullify the decisions of the lower court. And therefore, those incumbents are likely to sail through. And we might not have any by-election occasioned by an election petition. We'll only have a by-election occasioned by death.
But my brother, that does not make us conclude that the Electoral Commission did a good job. Because the way county elections are managed and the way national elections are managed, presidential elections are managed, there are certain differences which are clear. And unless you take them into account, you can't understand that, in fact, these are two different elections working together, looking like they're the same. Even when you're transmitting results, by the time you are dealing with the top management of the Electoral Commission here, there are certain things which have happened. So I think, in my opinion, and that seems to agree with you, is the fact that we must, if we were to credit the Electoral Commission for doing a good job, let us limit ourselves to what we have seen at counties. But again, that judgment should not, operate mutatis mutandis. You know, in the name of the law, mutatis mutandis, across the board, from the lower levels to the higher levels. It must be applied to specific situations. I think I can say the Electoral Commission must have done well from these petitions at county levels and manage elections well. The
5 positions. Yes. We have no issue.
Yeah, but then, but that would lead us to the discussion, why then did they allegedly, as some would say, bungle then the presidential to warrant unification and conversation. I don't want to get into Steve because he tells me I'm out of time. There we are. Thank you so much for watching Citizen Live at night. And Opinion Court. I'm Anne Kiguta. Good night. God bless. Have a great weekend. Bye-bye. Thank you, guys. Oh, sorry.